Now we will look into the various issues that are involved in copyrights and cyberspace, in relation to copyrights and cyberspace. Let me tell you one thing, internet raises a host of legal issues. There are lots of issues that we see day in and day out. Well, a person might be kind of committing an infringement or violation, carrying out a violation which could be intentional or unintentional. For example, I could go and search on Google, and there is lot of surfing and browsing one does, and there are lot of transient files that are stored in my system. Well, does that amount to copyright violation, because I am storing some temporary files? There are lot of such search engines which makes indexing of files or gives a lot of search reports. Well, does that mean the search engines are violating copyrights of the owner of particular those works? There's lot of in lot of places we see hyperlinks given to third party websites such as read more, or some links are given on third party websites are given. Well, does that amount to copyright infringement? There are a lot of people who write blogs, host content of third party. Well, is that a copyright infringement? So there are lot of issues with relation to copyright infringement because of this cyberspace in the cyber world. Before addressing any of such issues, one of the major issue that we will have to look into is the issue of jurisdiction. Well, there is no specific law in place which speaks about the jurisdiction in the cyberspace, and also you will agree with me that it would be really difficult for anyone to get in a legislation to this effect, because there are no geographical boundaries in for cyberspace. There are no boundaries at all. There cannot, determining jurisdiction will always be a little confusing in these aspects. Well, for example, I have designed or I host a website in New Delhi, and there is someone who is using or copying material from my website somewhere in Australia. Well, how do I tackle this? Where do I go and sue that person? How do I get to know that? So there are lot of jurisdictional issues with respect to how do I collect evidence for that. So there are quite a few of jurisdictional issues. Well, if you look into the traditional principle, we would have majorly three options as we look into. One is the law where the user of that content resides. One could be where the laws of the country that apply where the server is being hosted or where the transaction is taken place. So these are the three options that we have for jurisdictional related issues. Well, in the US there is something called as principle of minimum contacts, wherein the principle laid down by the court while deciding a case Zippo Manufacturing versus Zippo.com Incorporation held that two parties should have minimum contacts for a cause of action to arise and then take it to a particular court. So the three main principles laid down in this Zippo Manufacturing versus Zippo.com Incorporation case are whether the defendants has sufficient minimum contacts with the forum where the suit is being filed. Second, whether the claim asserted against the defendants has arisen out of those contacts, and third one, whether the exercise of jurisdiction is reasonable. So when the defendant establishes or the defendant questions the very principle of or the jurisdiction, and that case these principles have to be followed. Now coming to Indian law. In India, it's the Civil Procedure Code which basically governs the law of jurisdiction. In one such cyberspace related case is Banyan Tree Holdings Private Limited versus Murali Krishna Reddy. Here, the High Court held that jurisdiction of forum court, which is based on cause of action, does not get attracted merely because on the basis of interactivity of the website or accessibility in the forum and the nature of activity permissible, and whether it results in a commercial transaction has to be determined. For example, if the court says that it is very important for a commercial transaction to be taken place for one to go and approach a forum in that particular case. If it's just not about the accessibility of a particular website that is available, can be used for one cannot go to such forum. Now, the second one of the major issues is the liability of internet intermediaries. Before getting into the liability of internet intermediaries, we will just look into what are the different kind of liabilities, the principle of liabilities. There are majorly two forms of liabilities, one is the primary and the other one is secondary. Any direct infringement comes under the primary liability, and any indirect or contributory infringement for that matter is under the secondary liability. Now, for example, internet service provider. What does a internet service provider do? A internet service provider just acts as a medium who kind of connects the consumer or the main vendor to the end user. For example, multiple users, website owners go and host, and the end user just receives. It's just a internet is just a medium for receiving such usage. So, the internet service providers generally are categorized as to get under secondary liability, but they do have the primary responsibility of taking down the infringing content. One of the other important cases in this area of liability of internet intermediaries is MGM Studio versus Grokster Limited. You all know that MGM Studios is one of the major Hollywood studios. Their copyrighted contents, say sound recordings and audio-visual cinematographic films, were made available on Grokster's own online platform, which allowed peer-to-peer network sharing, as in sharing of files. MGM Studios went and sued Grokster Limited for primary copyright infringement, and the courts very clearly in that case laid down a few principles as to what is primary, what is secondary and what is contributory infringement, which I will read out for you and is available for you on this particular slide. The court said that one who distributes a device with the object of promoting its use to infringe a copyright, as shown by clear expression or other affirmative steps taken to foster infringement, is liable for the resulting acts of infringement by third parties, and further held that contributory infringement is committed by any person who intentionally induces or encourages direct infringement, and vicarious infringement is committed by those who profit from direct infringement while declining to exercise their right to limit or stop it. The Indian law, that is section 51A(1) deals with primary infringers, and section 51A(2) and 51B mainly deal with secondary infringers. One of the major cases and the popular cases in India was decided by Delhi High Court, that is Super Cassette Industries versus MySpace and others. Super Cassette Industries, popularly also known as T-Series, is a very popular music record label company in India, which holds a huge copyright repertoire with it. This MySpace and others had made available all the copyright content of T-Series without their own permission for online downloading and streaming. T-Series went and approached the Delhi High Court, and the Delhi High Court said that the making available the copyrighted content over any of these online platform without proper obtaining proper license or authorization amounts to copyright infringement. One of the other popular orders that the courts are today granting is the John Doe orders. John Doe orders are primarily those orders which are obtained against the parties that are unknown. Now, this was first time passed in the United Kingdom in 1852. To make it very simple, for example, you know that these days the piracy is so rampant that you get the movies online on the first day itself. The day it's released at morning 9 o'clock, by 12:30 in the noon, you have a pirated copy available online for you to watch a movie. So, here the owners of the films, like the producers of the big production houses, go and obtain these John Doe orders against various ISPs, that is the internet service providers, and multiple parties who are not known, unnamed parties, for them to take down these. So, what happens, the court in this case takes the application and grants a order wherein it asks the unknown parties or the parties infringing to take down these illegal copies that are made available online. For example, Singham, Bodyguard, Dhoom 3, these were the major movies wherein a John Doe order was secured or by the production houses or say granted by the courts. Similarly, Sony TV, which had the exclusive right to broadcast FIFA World Cup, had obtained a John Doe order. Star India, who had the exclusive rights to broadcast India-England 2014 Test Series matches, also had obtained John Doe orders. The other important area or the other important issues is the storage of transient copies or the right of reproduction. Well, everybody today surfs and browses internet. Every time you browse, there are some temporary files that keep on being downloaded on your system. So, this is one major issue, whether such downloading or browsing does it amount to copyright infringement. The European Court of Justice has laid down few conditions where the storage of transient copies do not amount to copyright infringement. You can see these conditions on the screen. The main conditions are: the act must be temporary, the act must be transient or incidental, the act must be an integral and essential part of technological process. The sole purpose of the act must be to enable a transmission of the work in a network between third parties via intermediary or lawful use of the work. The act must not have independent economic significance. So, these are few of the conditions which one has to make sure, and then as per the law there is no violation of copyright. These are the few major issues that we see. One of the other important issues is the violation of moral rights in cyberspace. Today, with the evolution in digital media, it is very easy for one to mutilate or distort a particular work. For example, there are rampant amount of moral right violations that are happening because of these cyberspace. So, these I would like to conclude with these various issues. I would request all of you to do read our entire e-module as well as the references that are given. We again say that this is an advanced topic and this has not been dealt exhaustively. There could be lot of issues that wouldn't have been covered, or there are lot of issues which still the courts have not had an answer, or which are unresolved. So, such issues have to be, if one is interested, one has to have an in-depth reading for those issues. Thank you.